Hello and welcome to our final episode of Civics, the Law, and You, a video series that we've conducted this year to introduce students to various aspects of the role of the judiciary and the courts and what lawyers do. The first episode back in October dealt with the voting rights and your rights and responsibilities as voting citizens. The second program that we held in February dealt with the rule of law and the role of the judicial branch in that aspect. Today's episode is actually going to focus on Supreme Court and particularly two cases. But before we begin and before I turn the program over to our moderator, President Jerry Schnurr of the Iowa State Bar Association, I do want to just let you know that this program will be recorded, but we do have a live audience. And if any of the people within the live audience want to ask questions during the presentation, they can do so in two ways. One, you can raise your hand virtually. I will do that to demonstrate. Raise my hand, and then we will know that you have a question and we can go ahead and call on you. The other way to do that would be to go to the chat function and post your question. You can either do it directly to me, find John Wheeler in here, or you can go ahead and post the question to chat to all, and either Jerry Schnurr or myself will see your question and pass it along to the presenter. So let me check to see if there are any questions before we begin about the procedure. This is called wait time. All right, then I will go ahead and pass the moderator responsibilities over to Jerry Schnurr from Fort Dodge, Iowa, who serves as the president of the Iowa State Bar Association.
Thank you, John, and thank you for joining us today. This is the third installment and the final this year of our project to enhance civics education and provide a resource to Iowa teachers to help with various areas of civics education. This and other recordings and materials can be found on the Iowa State Bar website under Civics, the Law, and You. Today we are very, very lucky to have with us two professors from the University of Iowa College of Law. Today we have Emily Hughes, who's a professor and associate dean at the University of Iowa College of Law. She was born and raised in Iowa and practiced law and taught in Boston, Chicago, and St. Louis before returning home to teach at the law school. She's a former Iowa State public defender. Her work focuses on criminal law and the ethics of lawyers. Todd Pettis is a professor of law at the University of Iowa College of Law also. Before he came to the University of Iowa, he practiced law in Seattle, Washington as a civil trial lawyer. His work focuses on state and federal constitutional law and the federal courts. He's written a book on the Iowa Constitution, and he appears often on Iowa Public Radio's River to River program, where he discusses cases that are pending or have been decided by the Iowa Supreme Court and U.S. Supreme Court. He's a frequent speaker on issues concerning freedom of expression, particularly on public campuses. Today, we are going to talk about two primary issues. Professor Pettis will discuss a case that is currently in the U.S. Supreme Court that involves an issue of a school district's power to regulate speech by students that occurs off campus. And this involves speech in social media by a student off campus, and she was disciplined by that. And so the case has worked its way up into the Supreme Court. And the next issue then is an issue involving criminal law and criminal procedure. Professor Hughes will discuss a case that's also pending in the U.S. Supreme Court. And I think both of these cases, the decisions are going to be coming down probably sometime this year, but I'll let them correct me on that as law professors are really good at doing with me. So, but this involves an issue of a police officer's authority to search or seize another person without a warrant. The limits of power by a police officer or the government. So I hope you enjoyed this session. I know it's going to be very informative and very good. We have two excellent presenters and great materials. So with that, I'm going to turn it over to Professor Pettis to go first.
Okay, I'm happy to do that. Let me share my screen, see if we get that far successfully, and if so, we're off and running. Okay, Mahanoy Area School District versus BL. That's the case I want to talk about. It was orally argued, meaning the attorneys representing the parties appeared in the United States Supreme Court just a few weeks ago at the end of April. The Supreme Court always tries to finish its work for the year, meaning what the Supreme Court calls a year, by the end of June. So we're recording this in mid to late May. Sometime in the next month to a month and a half, we'll get a ruling, unless something very unusual happens that causes the court to delay. So this case involves a cheerleader. You look at her. Her name is Brandy Levy. She looks like a very unhappy cheerleader, and indeed, she was a very unhappy cheerleader. She was attending a high school in a rural school district in Pennsylvania, kind of halfway between Harrisburg and Scranton, if you know your Pennsylvania geography. She's a freshman. She was 14 years old, and she was a member of the junior varsity cheerleading team. She wanted to be on the varsity cheerleading team. So at the end of her freshman year, she tried out and she didn't get it. She's very unhappy about that. The next day, that was on a Friday. The next day is a Saturday. And so she goes to a convenience store with a friend called the Cocoa Hut. I don't know why, but I love the fact that that's the name of the place where they went. So they went to the Cocoa Hut and went on Snapchat. And while in the Cocoa Hut, the owner of that convenience store, surely having no idea that what was about to happen was going to wind up ultimately the United States Supreme Court, they posted the photograph that you see here on Snapchat. And you know, the way Snapchat works, you can post a text or you can post a photo, but it's not up there permanently. You know, someone watches it, it disappears just within a matter of seconds, and it's not even up there waiting for viewers to see it for more than a day or so. So on a Saturday, they post this, and I'm going to say the word, so my apologies if anyone finds the language offensive, but the offensiveness of the language is kind of the point of the case. That's her on the left. She posts the photo that you see with her friend, middle fingers raised, saying, "Fuck school, fuck softball, fuck cheer, fuck everything." The softball, she had tried out for a particular position on a private softball team having nothing to do with her school. She didn't get the position that she wanted. She wasn't happy with how the school year was going, and especially she wasn't happy about being denied this position on the varsity cheerleading team. Well, she's got about 250 friends or so on Snapchat. They see this, and some of them are on the cheerleading team. One of those cheerleaders, her mother is the coach. And so one of the cheerleaders who sees this goes to her mom, who's a coach, and the mom is disturbed by this. And some other members of the cheerleading team see this photograph and the message, and they're not happy, and they go to the other coach. There's two coaches of the cheerleading team. And the two coaches decide that they're going to discipline her, and they're going to tell her that she is now ineligible to be on any cheerleading team, whether the junior varsity or the varsity, for her entire sophomore year, which was her upcoming year. And if she wanted to try out for the cheerleading team for her junior year or senior year, she could when that time came. And so she filed a lawsuit, Brandy Levy did, and she filed it claiming that her rights under the First Amendment to the United States Constitution were violated. Now, the language of this very important amendment is very short, you know, fewer than half a dozen words here in terms of the words that matter. And what the First Amendment says is that the government cannot abridge the freedom of speech. It's the speech clause. And she says that her rights under the First Amendment were violated. Now, let me say just a few things about the First Amendment to try to set the context, and then I've got some other slides that I'm going to turn to here in just a few minutes, having to do with what the Supreme Court has said up to this point about the free speech rights of kids and young people who are in K-12 public schools. But first, again, let me just say some general things about the First Amendment. And I started to put slides together for this, and I just thought I'm getting too far into the weeds. So let me just kind of talk quickly through it. First of all, note that we're talking here about the government. We're talking about people who are in public schools. So if we're talking about someone in a private school and those private school officials want to discipline a student, the First Amendment has nothing to say about that. The First Amendment says to the government, you cannot restrict people's freedom of speech. And our listeners here, my guess is, just like Brandy Levy, students or teachers in public schools. Okay. Now, there's an awful lot of law out there about what this clause means, having nothing to do with students. So just in general, talking about the freedom of speech, there's all kinds of law out there, and some phrases that might be familiar to you, like you may have heard the phrase public forum or something like that. And there is a large body of law having to do with speech on government property. And when we talk about government property, those are called forums, a government forum of some kind. We talk about public forums or non-public forums, and there's other kinds too. Well, that part of the free speech clause, that part of free speech law has nothing to do with Brandy Levy's case, because she said what she said at the Cocoa Hut, and she sent it out over Snapchat, and neither of those is government property, okay? Privately owned entities. There's some other law out there that talks about whether a regulation of speech is a time, place, manner restriction. And I say that only because I want you to know, not because I want you to know it for this presentation, but just I want to make a little connection to it if it's something you've heard before. And when we talk about the government making time, place, manner restrictions, there's a lot of law out there about that cases that various courts have decided. And what that law basically says in a nutshell is that if the government is responding, adversely, responding negatively to speech for reasons having nothing to do with the content of the speech, then and I'll unpack it just real quickly what that means, then the odds are pretty good that the restriction is going to be okay. I'll give you an example. You go out tonight in the middle of the night with a megaphone in your front yard or your apartment hallway, wherever you live, and you start just blaring out your views about anything. I don't care, for my example, what it is. It could be about President Biden or former President Trump, or it could be your, what your favorite kind of crackers are, or how you feel about cheerleaders or whatever. And you're blaring it out through your megaphone in the middle of the night. And along come the police saying, you're going to have to pipe down. And I'm not going to pipe down. I feel strongly I'm going to say what I'm going to say. You can probably be given a ticket for disturbing the peace. And you say, well, free speech, I'm speaking. Well, this would be an example of a time, place, manner restriction where the government is showing up on your doorstep, telling you to pipe down and giving you a ticket of some kind if you don't, not because they have a problem with the content of your speech. It's not what you're saying that's the problem. It's the time of day and how loudly you're saying it that's the problem that's getting you into trouble. Well, that has nothing to do with Brandy Levy's case, because when the softball coaches got involved, when the softball coaches got involved, they got involved because of what you see there on the right side of the screen, the raised fingers and the language in the text. That's why they got involved. It's not like, oh, you were on Snapchat. I don't care what you were saying on Snapchat. We've got a problem with Snapchat. It's not that. It's the content of what they said that got them into trouble. Okay. And the last thing that I want to emphasize, and I kind of glided past it quickly, but I just want to make sure it's clear, because we're talking about public schools here and a public schools cheerleading team, we are talking about the government. And I glided quickly past that, saying y'all are affiliated, I'm assuming, with public schools, not private schools. But if you're at a public school, that's the government. It's the government that runs that school. It's the government that hires those teachers. It's the government that sets the curriculum. And so that's all included within the First Amendment. So she's attending a public school, gets in trouble on her cheerleading team, and the government, through these softball coaches, if you will, these cheerleading coaches, the government is saying, you're not eligible now to participate in this student activity for another year. Okay, so let me show you just real quickly here. There's 4 times where the United States Supreme Court has had to say something about the free speech rights of children and young people in K-12 schools. And these cases matter because, as I've just, by talking you through, this idea of forums and time, place, manner restrictions and so forth, if that speech that you see there on the right, if that's just happening out there in the regular adult world, separate from schools, that, imagine Brandy Levy is sending that to a friend or sending it to her parents. Okay, just out there in the world, or you're walking down the street, you hear people using language like that or using that gesture. That's protected expression. In most ordinary circumstances, using that word, making that gesture, it would count as free speech. And I need you just to take my word for that here, because in my 20 or 25 minutes, I can't tell you all the reasons why, but just take my word for it that out in that adult world, it might be rude, it might be bad manners, it might be offensive, but it's protected expression. And so if, in fact, the First Amendment does not protect Brandy Levy here, if the First Amendment gives her no protection such that the government, the school, is allowed to punish her, it's going to have to be something to do with the unique power of schools, kindergarten through 12th grade schools, to monitor the speech of their students. Okay, so these 4 cases I'm about to talk about are what we have to work with to give us some insight. Okay, well, when can or cannot schools intervene because they're troubled by the speech of their students? The most famous case is the Tinker case, and it's a case close to home because it comes out of the Des Moines school system during the era of the Vietnam War. And you see in the large photograph, Mary Beth Tinker, her brother John, and they wanted to wear black armbands to school to protest the Vietnam War. And the school officials had made clear, the principal had heard that this kind of protest was coming to school and had said, look, if any of you all show up with these black armbands, you're going to get suspended. And so the students had heard this. John and Mary Beth knew this, and another student had heard this, and they did it anyway. So they show up just wearing these black armbands. They're not chanting. They're not standing on their desks in the middle of class, leading some kind of a, political chant. They're just wearing the black armbands in a silent protest. Now that counts as speech, even though they're not speaking literally with their mouths saying something, and even though they're not writing something in text, the wearing of those black armbands counts as speech. It's expressive, it's sending a message. And sure enough, they get suspended. And so it causes a big local controversy, a lot of litigation. I included the photograph in the top left here just to show you, that's Mary Beth on the left sitting with her mother at a local school board meeting, and neither of them looks like they're having much fun. You don't know when you launch this litigation how it's going to turn out. The Tinker kids now are free speech heroes. It's a widely celebrated case. Certainly any student in a K-12 school ought to like this case and the way that it came out. But it's not always fun getting to that happy conclusion. And what the United States Supreme Court ultimately said in their case was that the speech was protected. Why is it protected? Because it is not going to substantially disrupt classwork or other school activities. The United States Supreme Court said these kids are not causing a problem. It might be an unpopular message. Vietnam War was a controversial war, and there were people who thought that any criticism of the war was somehow criticism of American soldiers, and so we shouldn't be doing that. There are other reasons for the controversy. But nevertheless, the Supreme Court said there's no evidence that this was going to disrupt the activity of the school, and so it's protected speech. Last case, and then we'll come back to the cheerleader case and see where all this leaves us. You know how when the Olympic Games are coming, the Olympic torch is run, and they run, what do they start in Athens, Greece, I think, and then they, the torch, the Olympic torch travels by one means or another, but sometimes by foot. People are running with it to the site of the Olympic Games. And the Olympic Games, the Winter Games in 2002, were set to be held in Salt Lake City, Utah. And so the Olympic torch was making its way. And when it comes through your community, if it does, it's kind of a big deal. You want to show up. And it turns out that in Juneau, Alaska, the torch is going to be coming by, and it's going to be coming right down the street where the high school is. And so the teachers say, look, the Olympic torch is going to be passing today. It's in the middle of the school day, but this is kind of a neat thing. And so we'll stop classes for a little bit. We can all go stand outside and we'll watch the Olympic torch come by. So they do. And when they do, a bunch of kids unfurled this sign. God only knows what it means. I mean, I know what a bong is. I know what bong hits, but bong hits for Jesus. Who knows what message they're trying to convey, but it's speech of some sort. They unfurl this sign. The principal sees it and says, take that down. And some of the kids say, nope, not going to take it down. And so they get suspended. They get in trouble for refusing the principal's demand that they take this down. The student who gets most in trouble files a lawsuit and says it's free speech. If I want to go out and say bong hits for Jesus, I can go out and say bong hits for Jesus. And the United States Supreme Court rules in favor of the school. You'll notice in these 4 cases, the Tinkers won the first case. The students have lost to the next 3, and this student loses here too. Why? For reasons having specifically to do with drug use. The Supreme Court holds that schools do not need to tolerate speech that promotes illegal drug use. All right. So now we come back here to Brandy Levy and say, so where does this leave us and her case? Well, we can kind of walk quickly through these cases. You look at the Morse case. That speech on the right-hand side has nothing to do with drug use, and so the Morse case isn't going to be relevant. Okay. What about Hazelwood? Well, that had to do with school-sponsored speech. Remember, it was the school that publishes the newspaper as part of the curriculum. And so the school, if speech is going to go out in the world, kind of with its implicit stamp of approval, because it is the high school's newspaper, that gives the school some leverage, I said, to be able to regulate the speech. Well, that's not what's happening here. There's no way that speech that you see on the right-hand side is school-sponsored. It's her phone, it's her Snapchat account communicating to her friends. There's no one who would look at that and says, oh, look what the Mahanoy Area School District is saying today about softball and cheer. This is clearly just her speech. Okay, so what about the Bethel case? Well, as this case has worked its way to the United States Supreme Court, the Mahanoy Area School District officials, again, the high school where Brandy Levy was a student, they relied pretty heavily on the Bethel case and said, look, this is vulgar and offensive expression. We don't have to tolerate it. You know, you compare it to the kind of speech that Matthew Frazier was engaged in. It's socially inappropriate. One of our jobs is to teach people how to engage in socially appropriate expression. So we have a right here to get involved if we want. The speech is not protected, the school district argued. And in the courts below, and again, you know, courts, our judicial system is structured into different layers. So you start at a trial court, okay, where they hear evidence. Maybe there's a jury if that's appropriate, and we get an initial verdict. And then there's a layer of appeals courts that handle a lot of appeals, and most cases end there. But then the United States Supreme Court will take 50, 60, 70 cases a year that they kind of select from around the country using certain criteria and say, well, we're going to address these cases because they seem especially important. At those first 2 levels of the judiciary, at the trial level, and then at that first layer of appeals, the school district relied heavily on this Bethel case and said, look at the picture, read the text, and tell us how that's different than Matthew Frazier. And the 2 lower courts both rejected that argument and said, Matthew Frazier gave his speech on a stage in a school cafeteria during school hours at a school assembly to the school community. She is at the Cocoa Hut on a Saturday with her friend. And the Bethel School District case does not mean, the lower courts say, that schools can kind of monitor the speech of their students 24 hours a day, 7 days a week. And whenever school district officials hear, she used a bad word. Oh, he used a bad word when talking to his brother. She used a bad word when she got hit in the head with a bat, out playing in a park or something on a Sunday. Kids shouldn't talk that way. Let's punish her at school. No, the lower court said that's just a rule for school activities during school hours, school grounds, that kind of thing. Okay. What about the Tinker case? What about substantial disruption? Well, this turns out to be the issue that provoked the United States Supreme Court's interest and why they've agreed to hear this case. And the question is, when you look at the Tinkers here, when they wore their black armbands, they wore their black armbands to school. Their speech, like Matthew Frazier's, their speech happened at school, on school grounds, okay, during school hours, in school events. They wore their black armbands to class and so forth. Okay, just like Matthew Frazier had. Here we've got these two young women who are at a convenience store on a weekend, engaged in speech that may or may not be substantially disruptive when school comes back on Monday. And the school is arguing, and we're right now, finally, as I close here, we're at the issue that the Supreme Court has been asked to decide. Does, there it comes, good, under Tinker, this rule that schools don't have to tolerate speech if it's going to be substantially disruptive, can schools discipline students for disruptive speech that occurs off school grounds? This is again, the Cocoa Hut. So is there anything geographic about this Tinker rule? The school is saying, look, if speech is going to be substantially disrupt, if student speech is going to substantially disrupt school activities, it shouldn't matter where the student is when they speak. They might leave school grounds. Let's say it's recess. And they're on school grounds, but then they walk across the street and send the snap. What should that matter? The school district officials are saying, if it's going to substantially disrupt school, we should be able to do something about it. Brandy Levy is saying, well, hang on. So you're telling me that schools can monitor their student speech on social media and elsewhere, though social media would be the easiest place to do it, 24 hours a day, 7 days a week? We're really talking about the schools then becoming Big Brother, supervising everything that any of their students say on social media that might be disruptive in the school community, and schools thinking then that they can just zoom in. In the interest of time, I'm going to skip past this so I can come back to it if there's interest. There's some question about, well, what about, if we say that students are free to say what they want when they're off school grounds? Well, what about off-campus bullying? The kid who's trying to get to school but is not yet on school grounds, and school officials want to go after the kids who are bullying him or her. Okay, and the last question, we're being recorded here, so predictions are hazardous. But if I had to hazard a guess, you're not paying anything for this, so it's cheap prediction. But in that spirit, I would not be surprised if the Supreme Court use this case as an opportunity to kind of speculate about social media, but not really say anything firm in terms of rules, and say, look, even if schools in theory have the power to punish students for speech that they produce on social media on a weekend off school grounds, is there really any threat that this speech was going to be substantially disruptive? And I have to say, that's kind of where my heart is. I look at that and I think, okay, these young women are pretty upset, but can I really say that on Monday, we're going to have a hard time keeping the school in order? There's going to be chaos. There's going to be kids refusing to pay attention because of how they're responding to this snap. I think that that's hard to believe. So I would guess the court's going to say this doesn't reach the level of substantial disruption. So even if Tinker does apply to speech that kids produce off campus on a weekend, it still is not substantially disruptive, and will save for another day the task of trying to sort out what about speech that does threaten to be substantially disruptive that happens on a weekend and so forth. But we'll see what the courts say. Professor Hughes.
Excellent. Thank you for the baton pass, and thank you so much, Todd. That was great. I really appreciate listening to it. I'm going to share my screen now, and we're going to switch gears and talk about criminal law for a moment. So here we go, getting into criminal law. So we're switching from free speech issues to thinking about when can a police officer follow you and enter your home. I called it hot pursuit in criminal law because you're going to hear us. We're going to talk together about what hot pursuit means. And the question, one of the questions that the court is thinking about is, when can police follow you into your house? Okay, so that's sort of the framework, and I'm going to talk about this picture that I have here in a moment. Okay. Thinking about what Todd just was telling you about, a case pending in front of the United States Supreme Court, here's another case pending in front of the United States Supreme Court. This one is Lang versus California. Just like Todd's case, This one has been argued in front of the United States Supreme Court, and now we're waiting for a decision. So we're switching gears and thinking about another thing that the Supreme Court is thinking about, this one having to do with when police officers can follow somebody into their house. Okay, so Arthur Lang had worked for 30 years in real estate. He had retired and he was living in Sonoma, California. He's driving around one night and he's in his car and he is playing his music really loudly. And then he's randomly honking. No idea why he is randomly honking, but he's basically driving along, playing his music loudly and randomly honking. It's so loud and, kind of so randomly honking that police are drawn to sort of think about what's going on with him, right? Like a police officer notices him and the police officer starts following Mr. Lang. So Mr. Lang's still driving, loud music, randomly honking, and the police officer starts following him at a distance. He's not right behind Mr. Lang, he's at a distance. Well, Mr. Lang keeps driving and he turns off of the main road he was on onto a residential street because he's heading home. The police officer makes the same turn. He's still quite a distance behind Mr. Lang. Mr. Lang turns again and he turns again. He's basically moving through residential neighborhoods towards his house. When he's about 100 feet from his house, the police officer turns on the overhead lights of his police car. At this point, Mr. Lang turns into his driveway, presses the garage door open on his automatic garage door opener, and moves into his garage. And then he presses the garage door closed and is starting to close the garage. At this point, Mr. Lang gets out of his car. He's in the garage. He's parked. The garage door is going down. It's not down quite yet. So envision, a garage door going down and it's almost down, but not quite yet. And that's what that picture was supposed to symbolize, right? A garage door going down, not quite down yet. The police officer has now gotten out of his car and gets to the garage door just in time to put his foot in front of the automatic sensor to stop the garage door from going down so that the garage door starts lifting up again. The evidence is that you couldn't even see the car anymore. The garage door was so far down, but the foot gets stuck inside the garage door and the garage door starts going up again. And lo and behold, there's a police officer standing in Mr. Lang's garage and Mr. Lang is looking at a police officer. And the police officer says something like, "Didn't you see me behind you?" And Mr. Lang says, "No, I didn't. I didn't see you behind me." So the police officer talks to him inside his garage, Mr. Lang's garage. And as he talks to him, he smells alcohol. And eventually, Mr. Lang gets citations, basically charged with driving under the influence of alcohol and a noise violation because he was driving around with, loud music. So that's the situation we have in this case. The police officer following him into his garage and whether or not that's okay. The things to keep in mind as we keep moving forward here is why the police originally start following him is all about the noise and the honking. Okay, so eventually Mr. Lang does plead guilty to the drug driving charge because his blood alcohol content is 0.245, which is 3 times the legal limit in California. So he eventually pleads guilty to that. But at no point does the state of California, at no point does the police say, I pulled Mr. Lang over because I thought he was driving drunk, right? The police officer admits, I didn't have any idea he was driving drunk until I was standing next to him in his garage talking to him, and then I could smell the alcohol. So before he pleads guilty, right, the first thing he does is he tries to get the evidence of the fact that he was drunk thrown out. And one way to do that would be to say, you didn't have a right to be standing in my garage where you smelled the alcohol, because that violated my right to be protected in my home and not have you follow me into the house. So you may be thinking, wait a minute, we're talking garage, we're not talking home. And that's right. Thinking about, can the police follow you into the garage? The way that the court is thinking about this is there's really not a distinction between the garage and the house. This is an attached garage to the house. And so really it's the same question. It's like, your home is your castle. That's part of kind of Supreme Court cases. Essentially, they say people inside their homes, it's like being inside your castle. No matter what kind of home you live in, people have a right to be protected and not have police officers just barge into your home, because your home is your castle and you have a right, of privacy inside your home. And that extends out to the garage. The only time that police officers can follow you into your house is if they have a reason to come into your house. And the classic reason is if they have a warrant, right? If they have a warrant to come into the house, then the courts say, we authorize the police to follow you into your house. Here, whether you think about it as Mr. Lang's castle or whether you think about it as his garage, the police didn't have a warrant, right? There was no warrant. It was just a police officer following loud music and sticking his foot in and pushing the garage, the garage door goes back up again automatically. So if you don't have a warrant, what would be the grounds for being able to get into the house? And here, the grounds that were argued and that as the court, as the case went up on appeal, is that, first of all, the officer had a right, probable cause is what that PC stands for, that the officer had a right to arrest Mr. Lang. And it wasn't for the noise violation. It was really interesting the argument about why the officer has a right to arrest him. And the argument is that it's because he didn't stop for me once I put on my lights. And then he's basically fleeing me. I tried to stop him and he did not stop. He kept driving into his garage and started to close it. That was the probable cause for the arrest. Not the noise violation, but the fact that he didn't stop. So if there's probable cause to arrest him, the argument goes, and the Court of Appeals of California said this made sense, was that the officer was then in hot pursuit. There was a misdemeanor violation, there was a noise violation, the officer has a right to stop him. Mr. Lang is refusing to be stopped by driving into the garage. And so that's hot pursuit, or Mr. Lang is fleeing the police officer. Hot pursuit and flight are kind of interchangeable. So that he's fleeing the police officer at that point. And so, because of these two things, there was probable cause to arrest him, and Mr. Lang was fleeing and the officer was in hot pursuit of him. It was okay for the officer to go inside the garage or his home and continue the investigation and ultimately charge him with the crime of drunk driving and the noise violation. So that's what the California Court of Appeals said. So Mr. Lang loses if that's the case, right? That is not helpful to him, and his guilty plea is going to stick if that's the case. He appealed that up to the Supreme Court of California, who said, no, we're going to pass on this one. But then he's got a right to continue to appeal it up to the United States Supreme Court. And lo and behold, he gets all the way to the United States Supreme Court, which is pretty unusual, but he gets all the way up there. And one of the things that the United States Supreme Court is looking at is, what is hot pursuit? What does this mean? So just a little background here, like Todd gave you some background on some prior cases that were relevant to the cheerleader case. Here's some background to some law relevant to this issue. So hot pursuit means there's probable cause to arrest somebody, and they retreat inside their house. They open up the door and go inside their house, or here they open up the garage door and go inside their garage. that is a retreat into the house. And the idea is they're doing that to thwart, and thwart's the word they use in the Supreme Court, that they thwart arrest. They're trying to dodge arrest. They're going into their garage so that I don't catch them, or they're going into their house so that I don't catch them. If that's the case, hot pursuit says that's one of the reasons that a police officer could follow you into your house without a warrant. So, thinking about the question that's in front of the court and all the different pieces of it, let's just look at that together for a second. It's if the police are pursuing you for a misdemeanor, remember originally it's the noise violation, and then it becomes you didn't stop for me. Is that an exigent circumstance? And that means like a special reason to follow you into your house without a warrant. So the different parts that the court's looking here is, there was a police officer who was following him. That's the pursuit of him. The misdemeanor is going to be really important. We're going to come back to that. The idea of exigent circumstances means usually you have to have a warrant, but here there was no warrant. So there's got to be some special emergency allowing the police officers to barge into your home or to barge into your garage, barging into your home or your garage without a warrant. Because the default is you've got to have a warrant. Okay, so we're up in front of the United States Supreme Court, and there's oral arguments, and to prepare for the arguments and to prepare the justices to be able to hear the arguments, as you probably know, both sides of the case file briefs, and Todd talked about the arguments that were made on behalf of the people in his case. I'm going to talk to you a little bit about what the arguments that were made for Mr. Lang and for the state of California. So first of all, Mr. Lang, his argument before the Supreme Court is the Court of Appeals of California got this all wrong, right? That we agree that you don't need a warrant to get into my garage or my home if there's an emergency. But here, there's no emergency. Like, what's the emergency? There was somebody driving with loud music who says he didn't even see the police officer, and it was just the lights that were turned on. Like, what's the emergency that somebody couldn't leave and get a warrant, or that they couldn't just go up to the front door and knock on the front door? Like, why do they have to stick their foot in the garage door and open it back up again? There's no emergency here, is the first argument. The second argument is, I said we were going to come back to misdemeanors, and this is that moment. The attorneys for Mr. Lang say, there shouldn't be a misdemeanor rule here that says for a misdemeanor, any kind of misdemeanor in the whole country, that a police officer can follow you into your house if they're pursuing you for a misdemeanor. That's just way too big, is what Mr. Lang's attorneys say. Instead, the third point is what Mr. Lang's attorneys want the United States Supreme Court to do is to say the rule should be that police officers look at this on a case-by-case basis, that we trust police officers to use their discretion, and they can do it. They can use their discretion and decide if there really is an emergency here that they have to follow somebody into their house, or if there's not an emergency that they don't have to follow somebody into their house. But there shouldn't just be a blanket rule that if somebody's committed a misdemeanor, the police get to follow you right into your house. So that's what Mr. Lang's attorneys argued in front of the United States Supreme Court. So the state of California gets to argue in front of the Supreme Court too. And this is really interesting. This is totally unusual. Usually, both sides take opposite positions, right? And Mr. Lang would be saying, you should reverse, you should disagree with the Court of Appeals decision and send it back down and basically, fine for me. And the state of California actually agrees with Mr. Lang and says you should vacate the Court of Appeals decision. This does not happen very often at all. So they basically are both agreeing to disagree about the Court of Appeals decision, but the attorney for the state of California is doing it on a different basis. And their argument is essentially you should draw the line at felonies. Like, this is a misdemeanor, and that's way too blanket of an exception. But if somebody commits a felony, then there should be a rule basically allowing police to follow them and everything that follows. So they have totally different arguments, or very different arguments at least, Mr. Lang and the state of California, but they're kind of on the same side. They both want the Court of Appeals decision to be reversed. So there's nobody arguing the other side, right? Because both, usually it would be the state of California and Mr. Lang arguing against each other. And here they have different arguments, but they're kind of arguing the same thing. So there's a voice that's missing over here. So something that's interesting about this case is that the court had to reach out and find somebody to make that argument. It's called a friend of the court or an amicus brief. And they recruited a lawyer who had worked for Justice Ginsburg. It's called clerking for Justice Ginsburg. Her name is Angela Rice. And they said, will you write the argument for the other side? Because otherwise nobody's going to be here to argue that. And so this attorney took the court's invitation to write the amicus brief, or the friend of the court, and develop the argument on the other side. And what she wrote is that what the court should do is say you can enter a home if the officer is in hot pursuit, and that all crimes, felonies and misdemeanors, you should put them all together. And basically, if somebody's in hot pursuit, a police officer is in hot pursuit and somebody committed a crime, the police officer should be able to go in. So there were arguments, and I'll just flag a couple of the interesting issues that came up in the arguments before I close here. One of them is Justice Alito was asking questions and basically was thinking about and asked the attorney for Mr. Lang, let's talk more about hot pursuit. Like, it's got to be hot and it has to be pursuit, right? So what's the emergency here? And you hear the court discussing, like, how are we going to develop the doctrine of hot pursuit? Where are we going to draw the line between what makes something an emergency and what doesn't make it an emergency? Another part of the questions that the attorneys get is that, some of you want us to draw this line between felonies and misdemeanors. But when a police officer is out in the field and in pursuing somebody, they may not know if it's a felony or a misdemeanor. And so if you're making us, if you're making a police officer kind of clock in their head, is this going to be a felony or is this a misdemeanor? That's too hard, right? Like that's too complicated. And that might not be the way to separate out these cases. That's another line of questioning. And another one, Justice Sotomayor is asking this one, is she says, maybe what we should do is we should say that exigency or emergencies, something that's making the officers follow somebody in, it can, but it does not always justify entering without a warrant. And this kind of goes back to the case by case. Police officers should have discretion and think about what, if they really need to go inside a home, if they think somebody's going to destroy evidence, if they think somebody has a weapon, right? There are reasons why a police officer might be justified, why there might be exigency or emergencies to get inside a house. But Justice Sotomayor asked a line of questions that said, maybe we should go that route and, give discretion to the police, but also say, just because you have an emergency doesn't necessarily mean you get in. You still may not be able to get in depending on what the kind of emergency is. So that's where we are. They've made the arguments, and we're waiting for this too. So as you're thinking about what you think is going to happen in this case, this is another one to keep your eyes on, is when can police follow you into the home? And when can they put their foot in the door and lift up your garage? And you're going to have to stay tuned because we're waiting for the opinion. And when it gets announced, I'm sure it's going to be in the newspapers and the radio and the TV. And so you'll have the inside scoop to tell folks what you think about that. Thank you so much.
Thank you for your presentations. I think, yep, I'm unmuted. I always have to check that still. Very good. I had a question, Professor Pettis, that came up, And if you have any questions, if anybody has a question, go ahead and put it in the chat or raise your hand. But one of the things I was thinking about, Professor Pettis, during your presentation is the young woman's speech was off campus. She was obviously being critical of the cheerleading and the softball and other programs. What would be the impact, perhaps, of being critical, say, writing an article in the local newspaper critical of a school play or an orchestra performance? What would be the bounds or limits of a decision that said, yes, the school can discipline somebody for this kind of speech off campus, being critical or potentially disruptive of the school? Would something like an article writing a bad review of a school play or bad review of an orchestra concert, or writing something critical of the school board or the principal or teacher, or talking about that, even what impact could that have?
Right. Well, this points, I think, to one of the problems that the school district is having. I think the school district's going to lose this case one way or the other. I could be proved wrong about that, but I'd be pretty surprised. One of the problems that they're having is trying to define the limits that mark the point at which students are speaking, but yet the schools can't touch them. And one of the things the school says is, well, if it's speech that's directed somehow to the school community, then we should be able, if we think it's going to be disruptive on Monday, we should be able to intervene because it's directed to the school community. This isn't just one friend talking to another friend. Like, suppose Brandy Levy was talking to that friend that she was with in the Cocoa Hut, but they're talking and she just says to the friend, you know, fuck softball, cheerleader, I'm done with it. And someone overhears her, runs back and says, guess what I just heard Brandy Levy say in the Cocoa Hut? That's not speech that's directed at the school community. And so the school is saying, well, so we probably couldn't do anything about that. But she sent this out on Snapchat to people who are members of the school community, other students, so we should be able to intervene. The examples that you give, you know, a review of a school play. Suppose a student goes to see the school play and just thinks that it's terrible and the actors in it embarrass themselves and so forth. So writes a very negative review. The justices, I think, are going to be strongly inclined to think, but now what's wrong with that speech? You know, when you look at Matthew Frazier, for example, who was engaged in socially inappropriate speech using this kind of sexually crude metaphors to trumpet the case for his friend for a student council position. And you compare that to the Tinkers who are protesting the Vietnam War. The Vietnam War is about a very important social issue. This kid's sexual metaphors for someone for student body president is considerably less important. So one way to think about it is to think, well, you know, one spectrum that kind of is running beneath the surface, no matter what the larger framework we say we're going to work within, is, are these students engaging, are they addressing topics, trying to engage in speech that people are going to be talking about out there in the real world? And, you know, reviewing theater performances, which maybe doesn't seem like that big of a deal to some, that's life in civilized society. What did you think about the movie? Well, let me tell you what I think about the movie. Adults talk about that kind of thing. But, you know, again, to come back to the real heart of your question, I think, you know, where does the boundary lie? That's one of the school district's problems. It's not their only problem, but that's one of their problems. Is I don't think that they have succeeded in clearly marking a line that the justices are going to find acceptable, because the line that the school district is currently championing is a line that would say 24 hours a day, every week, during Christmas break, holiday break, it doesn't matter. If we think that this speech will ultimately be disruptive, then we ought to be able to respond to it. And I think that that's going to brings the school far too much into the lives of students and really starts to intrude on the domain of parents. And this is something that I think conservative justices on the court, and liberal justices perhaps too, are going to be very sensitive to. Usually if my child on a weekend is behaving inappropriately, using language that's inappropriate or something while talking about her experience on a cheerleading team or a softball team, and the parents say, well, I'm okay with that speech. Her dad is helping her sue. Her dad's okay with this speech, but the school is saying, no, that speech shouldn't be permitted.
Okay. Elizabeth Angelina has raised her hand. I think she has a question. Elizabeth, go ahead and unmute yourself and ask your question.
Hello, my name
Hi.
is Elizabeth. So like my question is like people, like students for the cheerleader case, basically like many students, when they don't make a team, they want to express themselves through social media, and it was on Snapchat. So my question is, so what if like because many students happen not to pass classes or an activity, and they want to express themselves through social media. So so would they have to suspend all the students because they didn't make a team because they want to express themselves? Because that's what they do on social media.
Yeah, your question and your perception, Elizabeth, to me go to the heart of why I think Brandy Levy is probably going to win at the end of the day. This is just and this came up. Your point was made by justices of the Supreme Court during oral argument, saying, look, students get disappointed by lots of things. Lots of things upset them. The grade they got on a paper. They audition for a play and they don't get it. They try out to be the star wide receiver on the football team and they don't make it. There's lots of things that disappoint students. And so what do? They talk to their friends about it. How do they talk to their friends about it? Well, you can see 3 high schoolers sitting there on a bench all on their phones, and the odds are good they're sitting there texting each other. I exaggerate a little bit, but they talk through social media. That's how they're connected to each other. And so if we say that the school can supervise all of that and say, you're talking about a school subject right now, and so we're going to listen. And if we think that you might be disrupting things, the cheerleading coaches said, well, we have a rule that says you shouldn't speak disparagingly about school or cheerleading. And we also need people to trust each other and have good relationships with each other. Cheerleaders form the pyramid. The person on the top of the pyramid needs to be able to trust the people who are on the bottom. And you start talking negatively about cheer, it undermines those relationships, kind of trying to explain why it might be okay, why there'd be a problem here where there might not be a problem in some of the examples that you and the justices are using, where a student complains about a paper. But I think at the end of the day, the impulse you have is, we're talking, yes, about thousands and thousands and thousands of disappointed students who are talking about what they thought of the substitute teacher or their regular teacher or any of these other things that we're raising. And the specter of the school being able to supervise that all the time, I don't think is likely at the end of the day to sit well with a majority of the court. We sit here and make these predictions. It's a foolish thing for me to be doing because we get surprised all the time. But that's a real challenge, I think, that the school district has if they want to win this case, is trying to allay those concerns.
Would it be a different case, do you think, if there was some advocacy for action, not just saying, I'm mad at the school, I don't think I was treated fair, but let's get together and let's take over the student center or the lunchroom, and is that maybe a different case, do you think?
That would be a different case, yes. If you're saying, let's walk out, join me and walk out. If you think that this is BS or something, let's walk out. That's a different case. It's not to say it's a winning case, but it's closer. It may be a winning case, but at a minimum, it is a different case, which would raise, I think, harder issues. This is just a young woman who, in her language, is saying, I am really angry at a lot of people for a lot of things right now. That's
Okay.
what she's saying.
Professor Hughes, I have a couple questions for you, I think. And you talked about a warrant and probable cause. And we have the warrant or probable cause to search somebody or their property, or to seize somebody and actually arrest them. Tell us what a warrant is. How do you get a warrant? What do you have to do to get a warrant to search somebody's house or to enter their house or to seize them. And then tell us what probable cause means. Is that there's a standard for that? Explain to us if you can, please.
Sure. So about the warrant. So a warrant is the police officers want to get inside something, right? They want to do something. They want to arrest somebody, or they want to get inside your house, or they want to look inside your computer, or they want to look inside your cell phone or something like that. And what they do to be able to get the warrant is they approach a judge and ask the judge to review it and see if they've got if they have the legal grounds to be able to do that. And so a judge actually reviews it and says, yep, you're good to go, or nope, not good to go. And that's why we allow police officers to enter homes if they have warrants, is because a judge has reviewed it and, and said, there's grounds for you to be able to get inside the house, or there's grounds to be able to search this person's phone or to search their computer, something that, is very private to the person. A judge has said it's okay. So that's how you get a warrant. Your second question, I'm blanking. Your second question?
What's probable cause?
Probable cause. So
without a warrant. So to do that without a warrant.
Right. So there are different standards. Like the one everybody you hear about all the time is proof beyond a reasonable doubt, right? Like when you get to a trial and the prosecutor is arguing in front of you think about your favorite TV show, or you think about your favorite movie, what you hear a lot is proof beyond a reasonable doubt. And that is the highest standard in criminal law. But that's not really until you get to trial. Until you get to trial, there are lesser standards. And probable cause is one of those that comes, that's a lesser standard than proof beyond a reasonable doubt. And the idea is, again, there's a review of depending on what probable cause is, like what kind of probable cause review it is. But the idea is that that when a judge is able to review this, the judge will say, you had a legal right under this lower standard to be able to do what you did. And I'll just say that probable cause is kind of in the middle here. Proof beyond a reasonable doubt is the one everybody hears about in movies. There's a lesser one. There's even a step down from probable cause, and that's reasonable suspicion. Like if you just have reasonable suspicion that somebody did something, that's a little bit lower. And that's also another legal standard that has a lot of law behind it. And then there's one other lower one, which is a hunch. If a police officer has a hunch, and of all the things I've just said, hunch, reasonable suspicion, probable cause, proof beyond a reasonable doubt, a hunch doesn't get the police officer anything. Okay, so a police officer cannot enter a home or do something on a hunch. It has to be more than a hunch. It has to rise either to the level of reasonable suspicion, or a little bit higher level, which is probable cause, or a little bit higher, which is proof beyond reasonable doubt.
Great. How unusual is it like this for a case like Lang to get to the Supreme Court? We're talking about somebody driving with loud music and a potential drunk driving charge.
It is kind of like winning the lottery, because thousands of people want the United States Supreme Court to hear their case every year, and they only hear, it varies, but 60, 70, 80-ish cases, depending on the year. And so the fact that this case is in front of the United States Supreme Court is a big deal. But you never know which case is going to wind up. Even the smallest facts, right? This started with somebody playing their music too loudly in their car, ended up at the United States Supreme Court. So you never know which case is going to make it. But it is pretty unusual for any case to make it into the United States Supreme Court, let alone this one.
I have one last question for the two of you. For anybody that's watching this, if anybody's watching this, the students today or anybody that may watch it in the future, if they might be interested in going to law school, what's a couple quick pieces of advice you might have for these young people?
Emily, you want to go first?
I was going to say you, but I'll go first. So my advice, if you're in high school right now and you think you might want to go to law school, that's exciting to me. I love being a lawyer. I love talking with people about wanting to be lawyers. So first of all, that would be exciting to me. I'd love to talk more with anybody who's interested. If you're thinking, what do I do now because I want to go to law school later? My best advice right now would be to find things that you are passionate about and pursue your passion. And so if it's music, first of all, you can go to law school with any kind of college degree. You don't have to do pre-law. You don't have to do political science, right? You could be a music major, a biology major, a languages major. You could do pre-law, right? But I would say do what you love while you continue thinking about the law, because there's not one set thing you have to do before law school. So that's my first piece of advice. Follow your passions and do what you love. And because when you do what you love, you do well and you learn a lot. And then that will set you up well for law school. But the second thing I would say is good lawyers are good readers. And they also, and when you're a good reader, then you also become a good writer as well. And so I would say find things that you love to read and develop your critical reading skills as well. So those would be my two things. Todd, what do you think?
First on my list was going to be right where you left off there. Opportunities to write, opportunities to read, and opportunities to speak. And you might say that sounds pretty basic, but it's pretty amazing how much of college you can get through that don't require you to do. Maybe they require you to do a lot of reading, but maybe very little writing, and certainly very little speaking in public. And it could be anything. If you're interested in theater, getting on a stage, you get used to being up in front of people. And you realize that if you misspeak or stumble over your words or something, the world's not going to end. Those little life lessons, it's nice to accumulate sooner rather than later. If you want to be on a debate team, fine, but you don't have to do that kind of speaking if you don't want to. And I think opportunities to read and opportunities to write. Writing is really hard. And I think the older you get, the more you realize that that's true. It seems simple at first, but writing effectively is a really difficult thing to do. And it's something that virtually all lawyers have to do well if they want to succeed. And so anything that involves, where you have to think and put the product of your thinking down on paper in some form is really valuable. And the last thing I would say, in addition to all the good things that Professor Hughes said, is if you don't have a lawyer in your family, you don't have someone to go to kind of seek advice on questions like Mr. Schnurr asked, so what do I do if I want to go to law school? If you don't have someone in your family to ask those questions, you just need to ask a teacher, or when you get off to college, one of your professors, and they can easily hook you up with someone who's an attorney, or with one of us whose job is to teach for a living. If we're doing this for a living, it's because we love the whole environment of being in law school. And if an email pops up in our inbox from someone saying, I'm a high school student or a college student, I'm kind of interested in law school, do you have a few minutes to talk to me? That is a fabulous email to get. It's the kind of thing we say when we go to lunch with colleges. I got an email today, someone wants to talk about going to law school. They're just a freshman in college and they're already thinking about it. We just kind of leap at those opportunities to make connections with people. So if you don't have someone in your close circle of family and contacts who's a law person, it's not hard to find us. You can go on our website and email one of the two of us. For those who are watching this, send Mr. Schnurr an email. He'd be happy to tell you why you ought to go to law school, or to help you evaluate whether law school is right for you, or any number of the thousands of attorneys in Iowa. You've got lots of attorneys in your town, no matter where you live. Some of them may be unhappy lawyers. A lot of them are going to be happy lawyers, and you can find your way to people who'd be really eager to be mentors for you.
Great advice. Thank you very much. I think that's all I have. John, I don't know if there's anything else we need to do, but I want to thank Professor Hughes and Professor Pettis for joining us today. It's been extremely valuable and really interesting. Keep an eye out for these decisions that will be coming out this year. And check out the website, Civics, the Law, and Us, Civics, the Law, and You, on the Iowa State Bar Association website. There are materials regarding today's cases. you can listen to the oral arguments. You can hear the questioning from the Supreme Court justices and the lawyers as they spoke. You can read their briefs. It's fascinating. I encourage you to go there and check it out. Thank you.
Thanks for having us.
Thank you very much.